SRIRAM's IAS, serving the nation since 1985. Ab offline ho ya online, we are the lifeline.
Hello friends, welcome to SRIRAM's IAS. I am back with another class of current affairs. This is the current affairs series which is going to help you in your upcoming prelims examination of 2025. This is class number 7 presented by me, Mayank, Bharadwaj. Now let us begin our discussion, and there is a slide for you to understand what we are going to discuss today. It's a very important piece of information pertaining to your prelims examination. The Supreme Court has ruled something on Article 22 of the Constitution of India. Something very important about Article 22 of the Constitution of India, clause number 1. Something has happened. अब आप सबको पता है आर्टिकल नंबर 22 क्या बोलता है. बहुत सिंपल सी चीज. अगर पुलिस या कोई भी ऐसी अथॉरिटी जिसके पास अरेस्ट करने की पावर है, ईडी हुई, सीबीआई हुआ, any authority, any legal authority which has the power to arrest somebody, they must tell to the person immediately and simultaneously while arresting the person the grounds of arrest. On what ground are you arresting me? On what charge are you arresting me? That must be told to the person who has been arrested. Simply means to the arrestee. पहले तो आपको ground बताने. That is very very important. At the same time आपको एक चीज और बहुत इंपॉर्टेंट एंश्योर करनी रहती है. वो ये रहता है कि मस्ट बी प्रोवाइडेड, द अरेस्टी मस्ट बी प्रोवाइडेड विद द लीगल प्रैक्टिशनर ऑफ हिज चॉइस टू डिफेंड हिमसेल्फ. ओके, ये बात बोली गई है क्लॉज नंबर 1 ऑफ आर्टिकल 22 में, विच इज नाउ इन क्वेश्चन हियर. आर्टिकल 22 का क्लॉज 2 भी बहुत अच्छा है, जो कि बोलता है कि 24 घंटे के अंदर यू हैव टू प्रोड्यूस द पर्सन इन फ्रंट ऑफ द मजिस्ट्रेट. ओके, सो वी आर गोइंग टू स्टडी दिस. अ पर्सन was arrested in Delhi on serious charges of profiting from pornography and other stuff, which is very inhuman activity and also antisocial activity, but the person was not conveyed the grounds of arrest. Now this is the violation of the constitutional right of the citizen of the country. Okay, तो कोई भी लॉ हो, टाडा हो, पोडा हो, टेररिज्म एक्ट हो, इलीगल एक्टिविटी एक्ट हो, किसी भी किस्म का एक्ट हो, is not above the Constitution of India. The Constitution of India provides this right, this fundamental right to every citizen, that whoever is arrested, not only to the citizens of the country, it has also been extended to foreigners, except person under preventive detention. Okay, these are two exceptions you must know. First one is, if a person is arrested under preventive detention, none of these things which we have discussed under clause 1 and clause 2 applies. Second, if the person is a enemy alien, a country which is enemy of India, if the person belongs to that country, then none of this applies. What we have discussed, that he must be told the grounds of arrest, and he must be given a legal practitioner to defend himself, and must be produced in front of the magistrate. None of this applies if a person is an enemy alien and if a person has been arrested on preventive detention. नहीं तो कोई भी हो, citizen हो या बाहर का व्यक्ति हो, कोई foreigner हो, the person must be told, must be conveyed immediately and simultaneously while the arrest is taking place, in writing, the grounds of arrest. Okay, now this is a very important piece of information for a prelims examination. Must remember this. Now let's see what happened. So what is the context here? Supreme Court recently held that it is a fundamental right for anyone arrested to be informed the grounds of their arrest without delay. 11:30 बजे गिरफ्तारी हुई सुबह. अगर आपने बंदे को थाने में बिठाए रखा 6:30 बजे तक, शाम तक, और फिर अरेस्ट मेमो देके बोल रहे हो कि ग्राउंड ऑफ अरेस्ट ये है, या फिर उस समय भी नहीं बताया, लेटर ऑन, देन दैट अरेस्ट इज इलीगल. विदाउट डिले, immediately द ग्राउंड्स ऑफ अरेस्ट मस्ट बी टोल्ड। उसके कुछ कारण हैं, हम वो कारण पढ़ेंगे अभी कि क्या कारण है, बट वो कारण है और बहुत ही इंपॉर्टेंट महत्वपूर्ण कारण है। आप बोल सकते हैं ना कि ठीक है पुलिस वाला भूल गया, क्या दिक्कत है, बाद में बता देंगे, ठीक है। कोई भी बेलेबल नॉन बेलेबल ऑफेंस, इस तरह के ऑफेंसेस जिसमें आपको वारंट की जरूरत नहीं है, थिंक अबाउट इट। अगर वारंट की जरूरत है तो ग्राउंड तो कुछ ना कुछ लिखवा के लाए होंगे। अगर वारंट की जरूरत नहीं है और अरेस्ट हो रहा है तो मस्ट बी टोल्ड द ग्राउंड ऑफ अरेस्ट, ऑन व्हाट चार्ज आपको गिरफ्तार किया जा रहा है। एक और चीज है जो इसमें लिखी नहीं है बट इट इज वेरी इंपॉर्टेंट, आर्टिकल के अंदर लिखी नहीं है बट थ्रू द इंटरप्रिटेशन ऑफ द सुप्रीम कोर्ट इट इज कमिंग, that where the arrested person has been taken, the location must be told to the near and dear ones of that person. The location has to be told. A person cannot be taken to a location which is not known to the near and dear one of the person who has been arrested. Now this is another piece of information very important for you, for your examination. You must remember this. Now another thing, now this is what quote unquote the court has said. Now let's read what is this. Once the ground of requiring a person's arrest have been formulated in the investigating officer's mind, अब कोई आईओ है, कोई इन्वेस्टिगेटिंग ऑफिसर है, उसने दिमाग में सोच लिया है कि इस बंदे को अरेस्ट करना है क्योंकि कहीं ना कहीं क्राइम में इसका इन्वॉल्वमेंट दिख रहा है, लग रहा है, समझ में आ रहा है। पुलिस पहले तो इन्वेस्टिगेट करती है ना, और फिर जो भी समझ में आता है कि यार ये कर सकता है, इसको अरेस्ट करो, अरेस्ट करके कस्टडी में रखो। जुडिशियल कस्टडी में जाता है, उससे पहले पुलिस कस्टडी भी, इफ द पुलिस रिक्वायर्स द पुलिस कस्टडी फॉर फर्दर इन्वेस्टिगेशन, द रिक्वेस्ट इज मेड टू द कोर्ट एंड इफ द कोर्ट gives the permission for judicial custody, the person remains with police for 2 days 3 days, but there is a limitation. judicial custody ही ज़्यादा होती है, पुलिस कस्टडी बहुत ज़्यादा नहीं होती है, there are limitations on that. So if the person who has been arrested and is in the judicial custody, okay, now let's see what happens here. He must have been arrested on something, you know, something must have been there in the mind of investigating officer before arresting the person. So simply convey it, no? What is wrong in conveying it? What is wrong in conveying it immediately and simultaneously while arresting the person? And if the law requires it to give it in writing, give it in writing. Why to stop? It is very important. Okay. So have been formulated in the investigating officer's mind, there can possibly be no reason why these grounds cannot be reduced into writing and communicated to the person simultaneously and at the time of arrest. That simply means immediately. So this is the whole context of our video, okay, that the grounds of arrest needs to be communicated to the person who has been arrested and they must be presented or conveyed to the person in writing. When the arrest memo is made, write it down. The grounds of arrest, if you are the investigating officer, you are the person coming to arrest a person, you have to be given in writing immediately during the arrest. Okay. So इस केस में क्या हुआ है, लीगलिटी ऑफ अरेस्ट क्वेश्चन हुई है। किन किन बेसिस पे? सबसे पहले तो ये कॉन्स्टिट्यूशनल प्रोविजन ऑफ आर्टिकल 22(1), वी विल सी दिस इन नेक्स्ट स्लाइड कि 22(1) बोलता क्या है। एंड सेकंड इज फेलियर टू कंप्लाई विद सेक्शन 50 ऑफ सीआरपीसी, section 50 of CRPC, arrest rendering it unlawful. So here is article 22 of clause article 22 of the constitution, clause 1 clause 2 are given here. So this is a mistake here, please forgive me. This is clause number 2 and this is clause number 3. Okay, protection against arrest and detention in certain cases. This is the heading of article 22(1). You must remember, the UPSC can ask a MCQ question on this in their upcoming prelims examination, because this news has bigger implications about human rights, about the arbitrary nature of the authorities, arbitrary nature of the police and the detention authorities, whether it be you know, CBI, whether it be ED or police or anybody, because so many important people have been arrested recently. Bail is the rule, jail is not the rule, is also something which has been said by the court. So bail also is important. Now for bail, some grounds has to be there. Okay, Article 22 plays a very important role in formulation of those grounds of bail. Okay, so let us just see. No person who is arrested shall be detained in custody. No person, जिसका भी अरेस्ट हुआ है, अगर आप उसको कस्टडी में रखे हुए हो तो होता क्या है? Without being informed as soon as may be the grounds of arrest. तो grounds of arrest as soon as possible उस पर्सन को आपको बताना होता है. This is simply we have understood earlier also. Nor shall he be denied the right to consult and defend himself by a legal practitioner of his choice. So clause 1 simply says two things. First thing which it says is about the grounds of arrest which has to be conveyed to the person as soon as possible, immediately during the arrest, and a legal practitioners of his choice. भाई अपना डिफेंस कैसे बनाएगा वो? अब उसको डिफेंस बनाने के लिए भी एक लीगल प्रैक्टिशनर लगेगा. दूसरा, वो जो लीगल प्रैक्टिशनर है वो इसके लिए डिफेंस कैसे बनाएगा? जुडिशियल कस्टडी में या पुलिस कस्टडी में अगर ये अरेस्टेड पर्सन है तो उसको बेल लेने के लिए कुछ ग्राउंड्स तो होने चाहिए. वो ग्राउंड्स कैसे पता करेगा अगर आपने ग्राउंड ऑफ अरेस्ट ही नहीं बताया है तो? सो द ग्राउंड ऑफ अरेस्ट हैज टू बी कन्वेड. और अगर ग्राउंड्स ऑफ अरेस्ट नहीं बताया है तो फिर ठीक है, फिर लीगल प्रैक्टिशनर की क्या जरूरत है? फिर फंडामेंटल राइट्स की भी क्या जरूरत है? अगर फॉलो ही नहीं करना है तो फिर जरूरत नहीं है, बट फॉलो करना है तो सब चीज की जरूरत है. ऑल द प्रोसीजरल एस्पेक्ट्स हैव टू बी फुलफिल्ड. दैट इज व्हाट इज रूल ऑफ लॉ, नॉट रूल ऑफ मैन. कि किसी दिन इन्वेस्टिगेटिंग ऑफिसर का मन करा कि इसको अरेस्ट करना है और उन्होंने अरेस्ट करके रख. दिस इज रूल ऑफ मैन, arbitrarily doing anything on the whims and fancies. But such a case is not possible in a country which is abiding by the rule of law. That is why this ruling is important, and hence we can say it's important for your examination. Article 22 का clause 2 बहुत सीधा सच्चा है. सिंपल बोलता है कि within 24 hours, okay, within 24 hours, such a person who has been arrested must be presented in front of a magistrate. In front of a magistrate. जो भी टाइम है उसमें से आपको ट्रैवल का टाइम माइनस कर देना है. फॉर एग्जाम्पल, इफ दिल्ली पुलिस गोज टू तमिलनाडु एंड अरेस्ट सम पर्सन, okay, so how that 24 hours must be counted? If a person was, let's say, arrested at 11 o'clock in the morning, legally he must be presented by tomorrow 11 o'clock morning in front of the magistrate. This could easily would have been done if the person was arrested here in Delhi, but the person is arrested in Tamil Nadu. So the travel time, the police was coming through this Indian Railway and it took 30 hours to come to Delhi, and there was a delay of 6 hours, so totally 36 hours. So whenever the person was arrested and whenever he has been produced in the front of the magistrate, minus 36 hours of travel, that time must be less than 24 hours. Okay, I hope you understood. It's a little technical thing, but it's an easy thing. Okay, now we have already seen that both these clauses does not apply in cases of enemy aliens and if the person has been arrested and detained for preventive detention. ठीक है. बाकी जो इस क्लॉजेस और हैं इस आर्टिकल के, क्लॉज नंबर 4, 5, वो बात करते हैं प्रिवेंटिव डिटेंशन की. दैट इज अ डिफरेंट टॉपिक ऑल टुगेदर. फॉर अस दीज इम्पॉर्टेंटली, फर्स्ट one is important, second one and third one, these three are important for us to understand in this particular case. Now coming to section 50 of CRPC, what does it say? Person arrested to be informed of ground of arrest and right to bail. ठीक है, ग्राउंड ऑफ अरेस्ट, इसका भी अपना केस सिर्फ इससे रिलेटेड है, ग्राउंड ऑफ बेल. सो क्लॉज नंबर 2, subsection 2 has not been written in this slide, it's okay. Every police officer or other person arresting any person, every police officer or other person, maybe at times there could be someone else who is arresting the person, Okay, the person could be anybody, you, me, a third person, anyone. If some police officer comes to arrest us or somebody comes to arrest us, what has to be done? Without warrant, and if the person is coming to arrest us without warrant, shall forthwith communicate. Now this forthwith word has been interpreted by the court as something. We will see what the forthwith word is very important. Shall forthwith communicate to him the full particulars of offence for which the person has been arrested or the grounds of arrest. Forthwith simply means here immediately, simultaneously. See, this is what court has said, quote unquote, section 50 CRPC, which mandates that the ground of arrest must be communicated to arrestee forthwith, that is to say simultaneously, immediately upon the arrest of some person, such person. So forthwith here simply means simultaneously and immediately. So simultaneously and immediately on making the arrest, the person who is arresting must in writing convey the grounds of arrest to the arrestee, to the person who has been arrested. Simple thing. So this has been written in section 50 of CRPC. The same thing has been written in article 22 clause 1 of the constitution, and nothing is above the constitution. Okay, this is what is civil liberty, fundamental right, everything is here. So it does not matter whether a person has been arrested for profiting from pornography or on as a terrorist or as for any heinous crime. If no the person who is arresting conveys the grounds of arrest, the arrest becomes illegal. It is very, very important piece of information which you must remember, not only for your examination but for general also. How police works, how governance works, it's important. Why compliance is needed? Now this is an important slide. Why are we talking so much about it? If a person who has been arrested on such a heinous crime, if there is a delay of let's say 30 minutes or 6 hours in conveying the charges on which the person has been arrested, what's a big deal here? So it's important here. Sufficient time must be given to an arrestee after the grounds of arrest are served in writing. So once you convey the grounds of arrest in writing, the person has it. Okay, now he gets sufficient time to call a legal practitioner to ask for his help for defense. Okay, so that legal practitioner comes up, makes a draft, makes a bail plea, goes to the court. So all this defense mechanism which is there, let's say police arrests a wrong person, or the investigation done by police is faulty, or the investigation is baseless, or the investigating officer is arresting a person just out of vengeance, anything. Now if the person who is arrested does not have any right, then it gives immense power in the hand of the arresting authority, in the hand of the police, to take arbitrary actions which is against the civil liberty, which is against the fundamental rights. So we have to understand why this particular right has been given to the people, why it is given to the citizens and also extended to the foreigners. It enables the arrestee to engage and confer with a legal counsel. Okay, we have seen this. The arrest must have meaningful opportunity. The arrestee, matlab the person who has been arrested, must have the meaningful opportunity to resist his remand to police custody or judicial custody. Again, I am repeating, this becomes important for the resistance. The person who has been arrested, who knows, maybe he is not the real culprit, maybe he is not the real person who the police was looking after. He must have some time, he must have some, some ground on which he can defend himself. That must be conveyed to him. And until and unless the grounds can be conveyed to the person who has been arrested, how can he present his defense in front of the court? Okay, I hope you understood. This is to save the civil liberties in the country, that the police should not go around and arrest anybody they like without conveying the grounds. Now, this again is a very important thing, relates to human rights and the fundamental rights. The slide says this, how this judgment can be applied for the advancement of human rights. Okay, it ensures transparency in legal process. Legal process. Again, section 50 of Criminal Procedure Code. So the procedure, we have two procedures very important of the procedures, Civil Procedure Code and Criminal Procedure Code. Why the procedures are there, that a thing has to be done like this only. First thing, it brings efficiency in the judicial system, in the criminal justice system. That is very important. Efficiency is important. Second, to enable the person to enjoy the rights given to them. If this procedure is arbitrary or runs on the whims and fancies of the police officer, they can do anything they want. That is the reason why they have been codified. That is the reason why it is very important for such authorities who are detaining to comply with these important sections. Okay, so it ensures transparency in the legal process, which is very, very important. Why you are arresting a person, how the person has been taken to custody, what has been done within the custody, are they really investigating or they're beating the person up. Okay, one important thing, that anything said in the police custody is not admissible in the court of law. Why? There are reasons behind everything. Okay. Legal representation must be meaningful and not just a formality. Now, it's a very important thing. Legal representation, nobody must be punished without giving them legal representation. Even when, such is the greatness of our country, even when Ajmal Kasab, who was arrested, and there was every reason to hang him immediately. He has killed so many people. There are videos which are showing him shooting down people, but still a legal representation was given to him. It took 4 years to prove, to hang him, to give him death sentence, and it took 2 to 3 years to prove that the person who you see in those videos is the same person who is standing in the court. Okay, is the person who came from an enemy country, and now he has done such an inhuman act which should not be done by any human being. So a legal representation is only possible when the country abides by the rule of law, and thankfully India is such a country. So legal representation, think about people who are not mainstream people, who are coming from far off villages, far flung areas, or tribal people, or so many other people. If extraordinary power is given to police to act arbitrarily, they can arrest anybody and put them into jail. The Indian jails are filled with such people. The case is not proved and the person is in the jail, and he doesn't have any resources to fight the case, to bring the surety for bail. So in such circumstances, it becomes very important to convey the grounds of arrest, because if there is no ground, what is the meaning of arresting a person? I hope you understood. Legal representation cannot be and should not be a formality. It prevents abuse of detention power and allows judicial intervention. Judiciary इसीलिए तो है, intervene करने के लिए अगर कुछ गलत हो रहा है तो. Judiciary upholds justice in this country. Okay. This strengthens human rights and upholds the rule of law. So this slide is very, very important, which tells you why we are studying this at all. Okay, why the grounds of arrest must be conveyed immediately and simultaneously to the person who has been arrested. I hope you liked this video. This was a very important piece of information for you, not only for your examination but also for you to learn in your life about how the police works, how the judiciary works, and why it is important to have a transparent procedure, and the authority, the arresting authority, why they should follow that procedure and be transparent to uphold the civil liberties. It's very important. So thank you very much for joining me, and have a nice day. We'll meet in the next class. Jai Hind.